Let's welcome Bonnie Yates. Bonnie is a special education attorney joining us as often as we can get her on Monday when she's not in IEPs or court. She is with the Tollner Law Offices, an amazing special education attorney expert, and she shares lots of wonderful information with us, especially during this time. Okay, saying hi to Jacinda. And hi to Christina and Jill and Parker, all of you. Welcome, welcome, welcome. So is Bonnie here? Bonnie, can you turn on your camera and your sound? And we will,
There she is.
hey, Bonnie.
Hi.
I heard you for a second, but I do not yet. There you are. You're popping up. Look at you. You look all lovely and official and professional this morning. Are you off to court?
Not exactly.
Okay. All right. Well, I won't press, but you look absolutely lovely.
Well, there are mediations and IEPs going on now, but I don't have one today. I have a couple later in the week.
So, well, but you look absolutely elegant.
Well, you always do. So
not even a little. But Bonnie, so excited that you're here. I was telling them that you're with Tollner Law Offices. Can you tell them a little about Tollner Law Offices, where to reach you, and the disclaimer?
I think I can do that. So Tollner Law Offices is an 8-attorney firm. We're based in San Jose. We have offices in Los Angeles and Orange County. You can find us on the web. Just look up Tollner Law Offices. We're an 8-attorney firm. We do special education, regional center, educationally related, civil rights matters, regional center, and we actually also help college students with disability related problems. Although that's not what we're going to be talking about today.
Well, I sent you a couple of questions last night, and we've had a question that was just written in saying hello to a friend of ours in Ireland. We got a lot of different people watching from a lot of different places this morning. And just so you know, Bonnie, we do our jargon of the day, and today our jargon of the day was faith. So we just talked a little bit about that. But okay. Somebody just wrote it in and said, I was just told we were offered teletherapy. Mm-hmm. Since we were offered teletherapy, we don't qualify for compensetory. He regressed and the OT was useless via Zoom. Do I have rights?
Okay, so I'm assuming that you are in the United States and you are operating under the purview of IDEA, and there's a general notion in special education law that if the district, let's say you're in the middle of a dispute with your school district and you've been taking your daughter to private counseling because you tried the district counseling and it was only 20 minutes and the personnel kept changing, and by the time you walked over to the room and got the session started, there wasn't really a lot therapeutically that was offered. Hopefully you gave 10 business days notice to your IEP team that you were going to pay for an outside service. And then the question, so in that situation, this typically comes up at mediation. The client shows us a receipt and they say, I had $7,500 worth of outside counseling. The district says, well, we offered the same amount of that counseling in-house, so we're not going to reimburse you for that. If the response is, yeah, well, but I didn't think it would be any good, so I didn't try it, that's not what this writer into the show is saying. They did try it, and it was inappropriate, it wasn't FAPE, and their child regressed. So something everybody's going to hear me saying a lot in the next few months, and I'm sorry that I have to say it, but people, you are not going to get anything unless you take your district to due process. If you are not able to do that, the district is just going to tell you what they're telling this person. But the truth of the matter is, if you file for due process and you raise the issue of the inappropriateness of the offered therapy and the efforts you made to access it and what happened and what documentation you have that proves that, then to me, you have a very good case for comp ed. We already know the school districts are internally talking about how they need relief from the federal government because they're on the hook for so much comp ed.
Yeah. So let's unpack what you just said. First of all, you got to cross your T's and dot your I's. You must give the school district 10 business days notice before you're going to start something that they're not paying for, or you're never going to be able to get the money back. You may still not be able to get the money back, but you won't have a shot unless you've given them 10 business days notice, correct?
And it's funny because you're sort of segueing into something that's quite different. And I was going to mention it on the show at some point because it's important. But I think running through the thread of our discussions, at least in California, and I suspect in a lot of other states, when you deal with a governmental entity, everything has to be documented. And that's because taxpayers are entitled to know these things and there has to be accountability. So for those of you, like I just talked to somebody that listens to the show, whose kid sustained a really bad bite from another child that broke the skin. I said, you got to file a claim form and put the municipality on notice, the governmental entity on notice that you're going to do this. Same thing with seeking, after the fact reimbursement for private services. The district has a right to know. The policy reason is the district is given 10 business days. So if they want to hold an IEP meeting and respond to your claim that you weren't offered FAPE, they have time to do it. So when you give them the 10 business days notice, tell them what you're purchasing and tell them why you have to purchase it. That it's a product of the district's failure to offer FAPE during school closure from March 15th till the end of academic year 2019-2020, and you can't let your child regress any further, so you have to do this.
Okay, so you got to start there. You got to make sure you do that. But then in this current climate, because so many people are saying that they want compensatory education for things that are missed, Bonnie is telling you that in all likelihood, you're not going to get any comp ed unless you're willing to fight due process, because there's just too many people. And it sounds like to me that's how they're weeding out who means business and who doesn't.
Well, we're seeing it over and over again. And like we had an extreme case over the weekend where LAUSD said they wouldn't do something. LAUSD is doing a lot of like, our union won't let us do this, or, we think it's too dangerous. But, then in this case, what we did, in this case, we wanted an IEE. And we requested the IEE from the district on the 24th of April. And because school was closed, nobody responded. And so we sent this to CDE, California Department of Education. Within days of the client filing that complaint, LA Unified contacted the family and said, here's the list of the people you can choose from. Of course, it wasn't a correct statement of law, but here's a list of 3 people who can do your outside evaluation. And, we're off and running. So, if that client had just accepted at face value that LAUSD was never going to respond, and the things I've been hearing from LAUSD is it's too dangerous. We're not doing assessments, and outside people can't do assessments. If outside people do assessments, the only portion of the assessment they could do would be non-face-to-face record review and a few other things. So you got it. And when I say file for due process, I want you to know it doesn't mean due process hearing. What it means is you file a complaint outlining or underlining your allegations of no FAPE. And then the first thing that happens once that, hits OAH is somebody from the district sends you a letter and says, do you want to have a resolution session to discuss your concerns and try to resolve them? That can happen within 10 to 15 days of filing the complaint. And then after that, you have a separate right to go to mediation. And typically that's where your case is going to settle. So I'm not saying you're all going to have to go to a due process hearing, but I'm saying you're going to have to go above the IEP level to deal with people that have any authority to deviate from the template that the IEP team has been given.
Hey, thanks for watching Autism Live. To subscribe, click here. And if you'd like to check out some more of our videos, click here.